Okay, let's go ahead and take up the next matter, which is People versus Ronald Norfleet. This is file 15-12072-FC. We have a motion that's been filed titled Correction of Sentence by the defendant. The defendant is here. He's appearing by video conference. Mr. Atwood is here from the prosecutor's office. Mr. Norfleet, well, I'll give you a short chance to speak as well, and then I'll hear from the prosecutor, and then I'll provide you some information regarding process. But I'll go ahead and give you an opportunity to speak. Did you have an attorney representing you on this case, Mr. Norfleet?
No, I was going to see if I can get one to be utilized during the proceeding. Well, I mean, when we get to if we get to some technical stuff or whatever, I mean, but pretty much I understand what's going on because I did the most. Okay.
Well, did you want to make any argument for me?
No, the argument was within the brief that I made. It's kind of simple. The prosecutor used the felony firearm to get me to a fourth degree habitual, and as far as the court's concerned.
Hold on, sir. We just lost you for a moment. Can you get a little closer to the microphone for me, please?
Yes.
I think you said the prosecutor used the felony firearm to get you to the fourth offense habitual offender. You can go from there.
Two of them. And and it's clearly established in Michigan law, federal law, whatever. I mean, I cited Honeycutt, but there's also a couple other cases that says that you can't use the felony firearm to habitualize anyone because the felony firearm has their own enhancement. And it's if you call the felony firearm one time, it's 2 years. You know how it goes. The second time is 5 years, and the next time is 10 years. So the court said you can't supplement the felony firearm to habitualize someone, which was clearly done in my case. Because I would be a second degree habitual, but now they got me as a fourth degree habitual because of the use of the two felony firearms. If the two felony firearms was not used, I wouldn't be a fourth degree habitual. So my argument was that they can't use it, and I cite the cases. I kind of was clear as I can in the my brief with People versus Honeycutt. It's kind of cut and dry. You just can't use it. That's what the court said. And they kind of in Honeycutt they did the prosecutor, but they put the onus on the judge with a trial court at that time. And if you look at everything that got to do with the felony firearm, it just can't be used to get you to the fourth degree habitual. There's no way it can be used to do that because they had their own separate enhancement.
Okay,
and it was used twice. It was used twice in my case to get me to a fourth degree. Now, had it not been used at all, I wouldn't be saying anything. But it's twice to get me to where I'm at. Otherwise, I would be a second degree habitual.
I understand your argument, sir. Let's go ahead and hear from the prosecutor, please, Mr. Atwood.
Thank you, Your Honor. Well, that is not what Honeycutt says. Honeycutt deals with supplementing a felony firearm with a habitual offender status. That's what the case dealt with. Felony firearm is an independent felony offense. It's an independent felony conviction. There are plenty of cases, and I pulled up a couple of them. People v. Carmouche, that's Carmouche, that's 112 Mishap 325. It's a 1982 case. Deals with, well, it really demonstrates that a felony firearm conviction can coexist independently with a habitual offender enhancement. Nothing in the two statutes mandate that a felony firearms sentence be vacated when a defendant is sentenced as a habitual offender or a habitual offender is dismissed. They exist independently from each other. The statute itself, the felony firearms statute, that's MCL 769.10, or the habitual offender statute, does not exclude any type of felony. It doesn't mention the felony firearm as being excluded. Certainly the legislature has done that in other situations. The legislature has excluded felony firearm status from carrying a concealed weapon, for instance, but it has not excluded that offense from the habitual offender enhancement statute. So there is no good law that states what the defendant is alleging. Honeycutt does not state that. Additionally, this was not raised below. This has gone through the Supreme Court. So this is a waived argument. This argument was not made until this point after the initial appeals were exhausted. So I think that is dispositive of the issue on its own, but certainly on the merits as well. If the court were to go that route, there's no indication that that felony cannot be used for enhancement. Thank you, Your Honor.
Well,
All right, thank you. Hold on. All right, Mr.
Okay.
Norfleet, I'll give you a chance to respond. Go ahead.
but let me say this: the issue is that to use the felony firearm, it's not like I had a felony firearm in this case. I had a drug case, and they was trying to get me to the fourth degree habitual. These are prior offenses. If you read Honeycutt, it says you can't bring up a prior. We talking about a prior felony firearm to enhance a case that I wasn't charged with felony firearm in this case. There's no felony firearm here. So I was already penalized for the felony firearm both times that they was brought up. You can't now bring it up and use it to enhance me as this plus to say, if you look at case law, it says if there's a miscarriage of justice, if it's an invalid sentence, which my case would be an invalid sentence because you're using two felony firearms prior felony firearms to get to her habitual, then you can correct the record or re-sentence at any stage if it's a miscarriage of justice. The miscarriage of justice is if I would be not if not for me having two felony firearms, my sentence wouldn't be habitual, and I wouldn't have this exorbitant sentence I got now for mind you half a gram of heroin. To get me to this again, I'm trying to be redundant, but for the sake of clarity, the Honeycutt and Camus case are totally different. That was from 82. This is from 87. They are talking about prior felony firearms, and that's what the prosecutor did in the Honeycutt case. He tried to bring up some prior felony firearms to habitualize this guy. I have already served the enhancement. One of them I got was 2 years. The other one was 5 years because I used a felony with a pistol in commission of a felony twice. But I have served for those times. I did 2 years for 5. Now you can't now bring it up, and so now you're using this to enhance and habitualize me. And Honeycutt clearly says you can't. Also, if you read Wayne County Prosecutor versus Recorder's Court, Judge 406 Michigan 374 389 280, and in this case from 79, they had that argument, and that argument ended in them saying that you cannot. It's almost like you're penalizing them twice. You can't use the felony fire that was prior to enhance what I got going on with the drug case. They just don't let you do it. And Honeycutt supersedes the case he's talking about. That was from 82.
Okay.
Your Honor, I'm sorry.
I'll give you a chance then, Mr. Atwood. You're welcome to respond.
Thank you, Judge. I pulled up Honeycutt, and I'll pull a couple of quotes from it because it actually supports the people's position. This is People v. Honeycutt, 163 Mishap 757. The defendant in that case actually made the argument that the defendant is making here, and this would be page 759. The court says, we begin by noting that defendant's argument that the felony... Sorry, Your Honor. We begin by noting that the defendant's argument that the felony firearm statute does not create a separate and distinct felony, but merely provides for sentence enhancement is incorrect. While some panels of this court in the past had taken the position that the Supreme Court has clearly held that the felony firearm statute creates a crime just separate and distinct from the underlying felony. Let's see. And indicates, again, the holding of the court was that the felony firearm statute may not be supplemented by the habitual offender statute. And so the trial court erred in that case by supplementing that 2-year. Says rather the trial court should have imposed the mandatory 2-year sentence on the felony firearm conviction and then imposed the sentence on the assault charge in that case as supplemented under the habitual offender statute with that second sentence running consecutively to the felony firearm statute. So that was not the holding of the case. It had to do whether or not you could habitualize the 2-year consecutive sentence, which the court did not do. Thank you, Your Honor.
All right.
Can I please retort?
Hold on, Mr. Norfleet, just a minute. It's my hearing.
Yes, sir.
I control it. All right,
Yes,
Mr.
sir.
Norfleet.
Yes, sir.
Hold on.
Yes.
Okay, that means shush until I allow you to speak. Mr. Norfleet, since I gave Mr. Atwood a chance to speak, you can go ahead and respond briefly as well, please.
Okay. I just he read something from Honeycutt. I want to read something from Honeycutt as well. That's all. It's brief. Okay.
Read slowly.
I read slowly. Okay. So, okay. In Honeycutt, it says, the two statutes, felony firearm and habitual offender, operate independent of each other and addresses entirely different societal harms which necessitate imposing a higher punishment on the defendant who violates either of those statutes to the criminal who merely commits the underlying substantive offense. The Michigan Court of Appeals further held, finally, we know that the felony firearm statute possesses its own habitual offender provision. The statute provides for increased sentences of subsequent now felony firearm conviction. The court in the instant case it's telling you, he's just reading the part he wanted to read, but it's telling you in this, if you read the whole case, I know you're going to read it. It tells you that you can't do this. Exactly what they remanded that case for is what they did in my case. Is use these prior things to enhance my sentence. The appeal courts did it or sent it back. And like I said, in case if you read the Supreme Court, they said you can't use it because they operate in two different things. And again, not to be redundant for the sake of clarity, you're using prior convictions. I've already served for those. You can't use them now. These only prior. Okay, so here would be another way to look at it. If you don't use the felony firearm, which is this why they use it, you have no other prior convictions to get me to the level of 4th degree. This is why these felony firearms was used. And the felony firearms can't be used. They already been used in the past. And this is why this case, one of the reasons it came about, but this case, if you read it, it supports my position. It really does.
I did read the case. I'm familiar with it. It's come up before. It's a well-known case here in the state of Michigan. The Honeycutt case is something that comes up every so often, and I'm able to respond to it for purposes of this motion. But first, I have to talk to you about process, as I told you I would do at the beginning.
Yes, sir.
Filing. I know you're acting as your own attorney today, and I have to hold you to the same requirements that I hold any other attorney to. You filed your motion pursuant to MCR 6.429. There is nothing in MCR 6.429 that allows you at this point in the process, after appeal, to file a motion to correct a sentence. That's something that's done very close to the entry of a sentence, which in this case would have been somewhere probably in 2015. You're now about 10 or 11 years late to file this. Now, there are still mechanisms that you can use in order to file a motion like this, and those are contained in Chapter 6500. You can write that down, 6500. That is the post-appeal relief section. I'm not saying whether you qualify or don't qualify under that section. I'll let you read that yourself. But that is the only mechanism, other than appeal, that you have to challenge this sentence. You didn't do so. You challenged it under the wrong section. And as a result, for that reason alone, I'm dismissing. But I also want you to know that you're wrong on the issue of Honeycutt. Honeycutt does not say that you cannot use felony firearm as a predicate to enhance a habitual offender. So you can use it. What you cannot do is habitualize a conviction for felony firearm because it has its own internal habitualization process. So that's what Honeycutt says. It doesn't say that felony firearm can never be used to enhance or be part of a enhancement process as a habitual offender notice. In fact, that's very clear under Michigan law sense. So you've misread the case, number one. And again, that happens sometimes. Believe me, I've had attorneys do that too. But number two, you have filed the motion incorrectly. You don't have the right to file this motion the way that you have. So for those reasons, I am denying your motion to correct the sentence. Mr. Atwood, if you provide an appropriate order to the file. All right, Mr. Norfleet, thank you, sir. Take care.
Thank you, Your Honor.
Before you go, can I get a copy of the transcript of what we just did, please?
Well, there's no transcript of it at this point. You'd have to request that through the normal process, and you're welcome to do so. All right?
Yes. Yes, sir.
Okay, thank you. Take care.
Before we wrap up, remember this. Every courtroom teaches a lesson. Confidence means nothing without knowledge, preparation, and respect for the law. Here at Reality in Court, we bring you real courtroom moments, legal battles, and the lessons behind every case. If you enjoyed this video, don't forget to like, subscribe, and turn on notifications. Thanks for watching, and remember, the law always has the final word.